there probably would be some advice that I would give the person at the side of the road. But I kind of suspect the motivation of Gary, whoever he is probably not that. Maybe I could be wrong, but I'm guessing, that the motivation is to get these people signed up right before somebody else gets to them. And now I know the Minnesota legislature stepped in, kind of in response to that comment. I don't know exact details, but now there are additional restrictions on the referral services. So I don't know if they're able to comply with those or not. But yeah, it's it's an area where there's competing interests. I don't want to say we should just do away with this entirely, because there are legitimate times. Or if I learn that my neighbor is in an accident, well, even if I don't do personal injury stuff, I might want to give them some advice. You better get this documented and find that out. So there's a legitimate reason for being on soon. But it's like many things, it can be abused. But if you do it by mail, you can put advertisement only envelope. And you can't.
The new rule is not advertised only. I thought advertising failed.
Oh yes.
The old rule is advertising.
Yeah, right. Yeah.
Okay.
Yeah, and if you do sell these things carefully, it's the actual rule. But good point. Yeah, the old rule said advertisement only. Now it says advertised material, which is the wording used in other states. So they just kind of reconciled that. I don't know why they had it slightly different to start with. What the rule is on soliciting people is you cannot solicit professional employment if your motive is pecuniary gain. So if you're not, if you're just giving up free legal advice to people on the street, that's okay. It's a question of whether or not you can take them. There are exceptions if the other person that you're contacting is a lawyer, then it's okay. So if I see one of you get injured, then I can chase you. Or if it's a family, close personal friend, or a private professional relationship. So you can solicit your former client. So you did the will for the person 5 years ago, and you saw in the paper that they just won the lottery. Call them up and say, you better update your will, or send them to another lawyer to do that so that you can be named as a beneficiary of it. But in any case, if the prospective client has made a desire not to be solicited, or it's using coercion, duress, or harassment, that's prohibited in any case. It says that the word advertising material on the envelope and outside the envelope. Now, we're getting back to the sending out letters to the people who are arrested for the weekend. If a lawyer was arrested for the weekend, then you don't have to comply with the other rules. Or again, your close personal friends and family or private clients. One person, well, what about Facebook friends? Well, no, they'd probably be your real friends. Not just, if you have 1,000 Facebook friends.
Really friends.
Yeah. I was in one program one time, I was sitting next to our former senator, Norm Culp, and I introduced myself. I'm one of your Facebook friends. And then he said, well, the first 1,000 I knew personally. After that, I lost track. And if you're a member of a prepaid legal service, they might do telemarketing. I wouldn't join an outfit that's engaged in telemarketing, but that's allowed. But if it turns out that the telemarketers from the prepaid legal service plan happen to call the people who were arrested this weekend, well, the rule makes clear that that's not a violation if you didn't know that. Now, Rule 7.4 constitutes a change, and that's communicating your field of practice. The actual wording of the rule has not changed a great deal. You're still allowed to communicate your field of practice, but it's a little bit wide open. So you are permitted to do that. If you're, they followed the model rules here, saying that if you're admitted to practice in the patent office, you can say that you're a patent lawyer. And here in this seagoing state, the Iowa Rule of Professional Conduct says that if you are engaged in admiralty practice, you may use the designation admiralty, proctor and admiralty, or similar. Now, people ask, well, why is that in the Iowa Rule? Well, first of all, because they took it from the model rules. And I once met an Iowa admiralty lawyer because he was retained by the owners of a ship that was sailing through Iowa on Interstate 80 that hadn't been paid for. So he arrested the ship in the admiralty jurisdiction of the Iowa District Court. So there is at least one admiralty lawyer in Iowa, and this rule makes clear that he put the words proctor and admiralty on his business card. Well, if you practice in a little bit less obscure areas of the law, yes, you can now say that you practice in a bigger field, and you no longer have to consult that list of proper terms for this. You can, as long as you're not proceeding, obviously, you call yourself whatever you want. So the attorney who specialized in military pensions, she is now allowed to advertise that she specializes in military pensions. She's not hamstrung by those old rules. Some lawyers are certified specialists in a certain area. So you're a certified real property specialist by the Iowa State Bar Association, or you are a certified trial lawyer by the American Trial Lawyers Association, or whatever they're called. Well, you're allowed to advertise that if you really are. Obviously, you can't be false or misleading, and you have to identify the organization that certifies. Now, so in other words, you're not allowed to just say, I am a certified real property specialist. You have to say, I'm a certified real property specialist by the Iowa State Bar Association. And in Minnesota, we have a board that gives stamp approval to accredit. That's the word I'm looking for. Such organizations. So, for example, Minnesota, the Minnesota State Bar Association is an officially accredited certifying organization. So this committee of the Minnesota Supreme Court sifted through these agencies, and they said, yeah, Minnesota State Bar Association, you have our permission to accredit or to certify lawyers as property specialists or whatever. Iowa does not have such a board. So in Iowa, what you have to say is that you have to specify that the Iowa Supreme, and there's some specific language that you use, but you basically have to say the Iowa Supreme Court does not accredit any such organization. That you have to identify who it is. So in Minnesota, for example, let's say I decide to branch out